Hello. Hello, everyone. Good morning for those that are in Europe. Good afternoon for those that are in Japan. It's 5 p.m. in Tokyo. Welcome to the Technology Transfer webinar number 18. Is April 27th, 2018. Today we're going to talk about patents and specifically opposition proceedings and nullity actions. It's going to be a little bit different from the usual webinar because, as you can see, we have a lot of presenters, a lot of speakers, and specifically we will have a moderator, Diane, and two speakers, Robert and Sonoda-san from Tokyo and Robert from Germany. So I would just introduce the help desk for a minute, just in a nutshell, give you some relevant information, and then give the floor to the speakers. So as you can see from this slide, I'm the project manager of the EU-Japan Technology Transfer Help Desk. If you don't know me yet, and now you do, this is my email, luca.sc@eujapan.grjp. If you have any questions, any feedback, even after seeing the other website that we're managing, the database of the help desk on the website that you see just right below my email. So I really suggest you to pay a visit to the website and please do provide your feedback. We are still running, actually, it's almost close, a survey for SMEs, specifically from Europe. So if you're interested, please do go on the website and you will be redirected to the survey. It would be helpful if you can fill it out. And finally, the last link is the one of the newsletter that you also find on the website of the help desk. So we would love to have you on board as a member of the mailing list. Without further ado, I would like to introduce the three speakers of today, starting from Sonoda-san. Dr. Sonoda is the managing partner of Sonoda&Kobyashi, a law firm founded 20 years ago. Yoshi-san has acquired extensive knowledge in various aspects of intellectual property rights over more than 30 years. And as the primary patent litigator, Dr. Sonoda handles appeals, invalidations, infringement proceedings for companies, public organizations from Europe and the US before Japanese courts. Dr. Sonoda regularly gives seminars abroad and at IP organizations and associations, and as today, of course, also for our webinar. The second speaker is Robert Börner. Dr. Börner studied general physics at the Technical University of Munich and completed his PhD studies at the Université Libre de Bruxelles in Brussels with research on chemical reactions on metal surfaces under high vacuum. In 2001, Dr. Börner started his training as a German and European patent attorney in a mid-sized Munich-based German patent firm, which he completed in 2005 by passing the German and European qualification examinations. Dr. Börner joined Murgitroyd in 2011 to build up and lead the German office and was appointed director, patents and trademarks in 2013. In addition to this experience in patent prosecution litigation of various technical fields, Dr. Börner also has a wide experience in matters relating to trademarks and regularly travels to Japan. Actually, last time we met for a seminar here in Tokyo that you can also watch on our YouTube page, and the times that he came here to enhance the cooperation with local clients and partners by presenting seminars about European and German patent and trademark practice. The last speaker today is also Diane Villiers, graduated from CEPI, the French IP Council's qualification, and specialized in comparative IP law, providing advice on the Japanese IP system. She is very attentive to corporations' business issues. She helps clients streamline their internal procedures and establish the best IP practice for Japan. She joined Sonoda&Kobyashi in 2008, and she speaks French, English, Japanese, German, and some Chinese. Without further ado, now you know almost everything about today's speakers. I would give the floor to Diane to start moderating. So Diane, the floor is yours.
Thank you, Luca, for the introduction. Can you hear me?
We can. Yes.
Yes, thank you. So here's Diane from Sonoda&Kobyashi. Thank you for all joining this webinar today. So we're going to discuss the countermeasures somebody can take to against the competitor's patent. So as you may know, in Japan as well as in Europe, there are two systems possible. One is the opposition and one is the invalidation. So let's discuss these two systems and the differences between the two jurisdictions. So we're going to start with Sonoda-san. Dr. Sonoda, could you please give us some basic facts about these two options in Japan?
Thank you, Diane. And good morning and good afternoon, everybody. So when our problematic patent is granted to your competitors, there are two options you can use in Japan. One is an opposition. The second is a nullity action. And there are, in fact, other means to attack the validity of the patent, which is to counter-argue at an infringement court. But we are not talking about that today, and we talk only about opposition and nullity action, both at the Japan Patent Office. Sometimes I say JPO, which stands for Japan Patent Office. The first one is opposition, and very briefly, opposition is different from nullity action by the fact that you can file opposition only within 6 months from the publication of the patent. So you must do it quickly. And there were 1,250 oppositions filed last year. As opposed to this opposition, you can use also nullity action. And for this, there is no time limit, so any time after grant, even after a patent is expired. Last year, 161 nullity actions were filed. So in total, about 400 oppositions and nullity actions filed last year to challenge the validity of a patent. And this number is relatively small because last year there were over 300 patent applications filed in Japan and almost 200,000 patents granted. So the opposition and nullity actions were filed for less than 1% of Japanese granted patents. So please go to the European facts.
Good morning and good afternoon. This is Robert Börner from Murgitroyd, Munich. The situation at the European Patent Office is a bit different. We have not 1% of patents opposed. In 2017, as you can see, we have 100,000, a bit more patents granted by the EPO. And the number of oppositions filed was about 3,900, it's 3.7%. And quite interestingly, from the patent oppositions, there are, 27, 28, so almost a third are successful, meaning that the patent has been revoked. Another 40% partly successful, meaning that the patent has been upheld in amended form. And for the rest, the oppositions had been rejected. And as you know, we will talk about that in detail later, there is no centralized nullity action against the European patent as granted at the moment. Being based in Germany, I go for the German nullity actions. And if you can see the invalidation proceedings at the Federal German Patent Court in 2016, there have been 284 filed and 400 were pending at that time. And there are 206 closed proceedings, either by the parties coming to an agreement or by a final decision. And quite interestingly, the number or the percentage in which the patent was revoked is higher. It's 43%. And the invalidation request was only rejected in about 21%. And the reason is that maybe as we'll see later, invalidation proceedings are more expensive, so maybe people think twice about starting them.
Well, thank you both for the introduction of the fact. So we understood that there is more opposition filed in Europe compared to Japan. So now, Robert, could you please tell us who is eligible to file an opposition at the European Patent Office?
Yes, I will start with that. According to the European Patent Convention, the opposition is open to any person. So quite interesting, you don't need any legal interest. So that's quite important. So you don't need to be sued by the patent owner in an infringement action to file an opposition. And there are some cases, some years ago, a trainee training for the European patent qualification, he just filed oppositions as a training. So he had no legal interest. He just did it to get himself up to speed for the examination proceedings, his own test before the European Patent Office. There is one exception, the patent owner. You're not entitled to file an opposition against your own patent. However, the inventor is. There's one more restriction within the EPC. The opponent needs to be identifiable. So it's not possible to file an opposition anonymously. However, if you want to stay anonymous, you have some options because you can use a third party as a straw man. And that is allowable unless your intent is really to circumvent the law. So even in this case, it shouldn't be possible to use a straw man for a patentee. But in the end, if nobody finds out, you will have no problem here. And of course, usually you use a straw man that is not linked to your company, meaning that you don't use your standard European representative for filing the opposition. Because, but usually you use another patent attorney law firm, and they just then file the case and hand in the statements, and then but your company and your standard representative stays in the background. One thing which is also interesting, if you start an opposition and then afterwards you sell your business or you sell the interest, somebody else is interested in the opposition, you can only transfer the status as an opponent as part of the complete opponent's business assets. So that's the situation at the EPO. Yoshi-san, is that different at the JPO?
Very similar, not exactly the same. So please let me explain the entitlement at the JPO. So at the JPO also, any third party can file an opposition. Legal interest is not necessary for that. So if you want, you can use a straw man to hide your identity. And there are some advices now we have in connection with this. And when you use a straw man to hide the identity, we recommend that you do not use the Japanese patent attorney you are usually using, because the opponent or the patentee can guess who is behind the patent attorney. So that is we did very often to find unrelated third party to file an opposition in his or her name. And
so let's talk now about the reasons that can be raised to oppose a patent. Please, Sonoda-san, go ahead and explain us what are the grounds at the GPO to oppose a patent.
Yes, thank you, Diane. With regard to the grounds to raise opposition, you can raise any grounds which could be used in the examination by the examiner, which means lack of novelty, of course, and lack of inventive step, a lack of support, clarity, or enablement, which is a disclosure requirement, and the introduction of new matter by amendments. You can raise this also, and double patenting or non-patentable subject matter. So almost all of the reason can be raised. But as an advice, we'd like to say that an opposition is not an inter-part procedure. Rather than that, you should think that this is an extension of the examination. Therefore, there is no exchange of opinions with the patentee, between the patentee and the opponent. And it is very important to convince the Board of Appeals, which makes a judgment on the opposition. And you should be aware that the board is not bound by the reason and evidence you submit to the board. Board might adopt the reason and evidence you submit, but may not. That's the discretion of the board. So could you, Robert, explain the situation in Europe?
Well, in Europe, the grounds for filing an opposition are laid out in Article 100 of the EPC. And there are mainly 3 points. The first is that the subject matter of the patent is not patentable under the Articles 52 to 57 of the European Patent Convention. And these are the, let's call it, standard reasons. It's a lack of novelty or lack of inventiveness. It's excluded subject matter like software as such or medical things. Then you have a lack of industrial application. The next possible ground for opposition is that it's a lack of sufficiency, meaning that the patent does not disclose the invention in a way that is sufficiently clear and complete to be carried out by a person skilled in the art. As I said, that's a lack of sufficiency. It's not a lack of clarity, as I will discuss in a minute. The third reason in Article 100 is that the subject matter of the application, of the patent, extends beyond the content of the application is filed. That's the Article 123(2) of the European Patent Convention, so inadmissibly broadening the original scope of disclosure. Interestingly, these are the only reasons or grounds for opposition which can be used at the EPO. So no ground for opposition is a lack of unity, a lack of clarity, a lack of support, formal issues, a wrong inventor designation, or whether the patentee is not entitled to the patent. And these reasons, you need to raise all grounds, all grounds which you raise in your notice of opposition, you need to really substantiate them. And the problem is at the EPO that if you want to have new grounds for opposition, let's consider a situation where you file an opposition and afterwards you base it only on lack of novelty and inventiveness, and afterwards you find out that the claims are containing subject matter which has not originally been part of the invention of the application. The problem with that is at the EPO, these new grounds for opposition, they're only allowable if prima facie relevant. Prima facie means, so at first sight, it's clear the grounds you try to get into the proceedings are highly relevant for the opposition for the patent to be revoked. In that case, new grounds can also be raised by the opposition division. And you also have to consider one point here. The grounds which are covered by Article 100A, meaning lack of novelty, inventiveness, on the one hand, excluded subject matter and no industrial application, these are dealt as separate grounds. So if you only substantiate and raise a lack of novelty, inventiveness, and later you find out that it's a complete software patent, you may have problems in getting that new grounds allowed in the proceedings. There is one exception. If the claims during the opposition are amended, and if the amendments are based on the description and not only on dependent claims, then the whole new claim set needs to comply with all requirements of the European Patent Convention. So meaning if the patentee amends his claims and enters features from the description, you may raise new grounds. And of course, you can then also raise further objections which are not mentioned in Article 100 of the EPC. So not only you can raise new grounds of the opposition, but you can also then start clarity objections, unity objections, and the opposition division needs to take them up. And our advice here, it's quite clear. Due to this limited possibility to enter new grounds, you should raise and substantiate all grounds for opposition in the notice of opposition. So if you really decide, I want to file an opposition, you should be well prepared, and you should put all your arguments and all your grounds in the first statement to be filed.
Thank you. So with regard to the time frame of the procedure, Robert, could you please give us more details on how it works in Europe?
Yes, I'm happy to do that, Diane, thanks. Usually the deadline for filing an opposition is 9 months from the publication of the mention of the grant of the European patent. 9 months is, in my view, quite sufficient, even if you need to have translations sent back and forward to outside parties, even if you have to carry out a search. But of course, that's only sufficient if you're aware of the patent. So if you have a competitor who is quite active, you may consider installing a patent watch on their patents, the pending patents, to be in the position to decide about a possible opposition in due time. The overall time frame for the opposition proceedings, it's quite interesting. The EPO, in the recent months and years, they try to speed up their proceedings. And they also have an initiative called the Early Certainty for Opposition. And the aim of that initiative is they want to lower the average time until a decision is taken in the first instance to 15 months. At the moment, we have a time frame of more than 2 years in average. So after filing your opposition, your decision will be rendered a bit more than 2 years from the filing of the opposition. There is linked with this initiative a rather strict deadline regime. So once you file an opposition, the EPO will forward it to the patentee, who's got a strict time limit to reply, and then the extension of time are only allowed in exceptional cases with the EPO. And officially, it's also planned that there will be only 1 round of submissions before the summons to oral proceedings. That means you file your opposition note, and the patentee will then reply. There is one point here. The summons for oral proceedings will be issued usually with several months after you receive the reply of the patentee. So then, of course, you have the possibility to send another reply. But officially, the EPO tries to limit the time for preparation of the oral proceedings, and to do that rather strictly. And as I said, just at the EPO, usually you have the hearing, the oral proceedings in opposition proceedings. It's usually the summons for the oral proceedings you receive at least 6 months before the hearing takes place. A hearing will take place if either of the party requested it or if the opposition division deems it helpful for the proceedings as such. And with the summons, you receive usually a preliminary opinion, and in that preliminary opinion, there will be the main issues which will have to be discussed at the oral hearing. Usually, the opposition division then states also, at the moment, we are of the opinion that novelty over document D1 is present, but it will be discussed at the oral hearing whether inventiveness in view of documents D1 and D2 is present. So they try to focus the people's minds on the discussions to be made during the oral proceeding. And after you receive your summons, you can have last statements to be filed 2 months before the hearing. And these statements usually are a set of claims and several requests, because in European practice you may file auxiliary requests in opposition by the patentee. And of course there will be an additional final statement by the opponent clarifying his final points about maybe some issues raised in the reply by the patentee. Usually at that time, in oral hearings, new requests or evidence is only admitted again if it's prima facie relevant. So if you sit in the oral proceedings and the other party then suddenly comes with another prior art, or you want to present a further prior art document, or the patentee comes with a new set of claims, many boards, many opposition divisions will just reject that as being late filed. At the end of the hearing, there will be a decision, and usually the decision will be either the patent will be maintained as granted, so the opposition is rejected, or the patent will be maintained in amended form according to one of the requests filed by the patentee, or the patent will be revoked. And after the oral proceedings, you will receive the minutes of the oral proceedings and a written decision, and that will follow within some weeks after the hearing usually. So that is a really rough overview about the opposition proceedings, the time frame, and how they are structured at the EPO. I think the most important to retain is you try to make your case as soon as possible, and usually you will have oral proceedings. So how's the situation back in Japan, Yoshi?
It looks like that one very important difference between Europe and Japan is that in the JPO, Japan Patent Office, there is no oral hearing for oppositions. And the time frame you can file an opposition is shorter, 6 months, and there is no oral hearing, and the decision can be expected within 6 months. So the opposition under the Japanese patent law is designed to be pretty quick and simplified proceedings. Please let me show the proceedings for opposition. When the patent is granted and published, the opponent has 6 months to file an opposition here, and once it is filed, the opposition is, of course, transferred to the patentee. But at this moment, the patentee is not even requested to answer, because this opposition is examined by the JPO, the Board of 3 examiners. And here, the board will decide whether there is a real reason for revocation or not. And if the board decides that there is no revocation at all, the board will reject the opposition without any reply from the patentee. That is this line. But if the board decides that there is a reason to revoke the patent, the board describes the reason and notifies the reason for revocation to the patentee here. And the patentee is requested to file a response, or if he or she wants, file amendments. It is here. And when the response is filed, what happens depends on whether the amendments are filed at the same time. If amendments are filed, these amendments are given to the opponent, and opponent can submit a secondary the opinion against the amended claims for the second time. If there is no amendment, the opponent is not given to submit their opinion. And then the examination continues and comes to a decision. However, that is not written here because it complicates too much the flow. As a result of the examination here, if the board comes to an opinion that the patent should be revoked, then the board will give the second chance to the patentee to amend the claims again. and examine the amended claims. And the final decision is made.
So, Sonoda-san, the opposition, let's say the opposition is rejected. Can we appeal the decision to maintain the patent? So what's the situation at the GPO?
Mm-hmm. Yes. What you can do depends on whether the patent is invalidated or maintained. If the decision is to maintain the patent, the opponent can do nothing. It is because opponent can file a nullity action any time. Therefore, there is no direct way to appeal and challenge the decision already made for opposition. However, in contrast, if the decision is to invalidate the patentee can file an appeal and in the IT High Court. And IT High Court might reverse the decision made by the JPO or confirm the decision. And in the reality, suppose that you file an opposition and the opposition is rejected, that is, the patent is maintained. It will be a little more difficult to invalidate the patent by nullity action because, no, I'm sorry, unless you have a brand new evidence to invalidate the patent. If the new nullity action is based on exactly the same evidence used in opposition, then if you file a nullity action, in order to find a different conclusion, that is to invalidate the patent by the nullity action, the JPO must find a good reason that the JPO made a mistake or was wrong in opposition, and now with a new argument, JPO is making a different decision, which is very difficult to happen. Therefore, once you fail in opposition, you must understand that to invalidate the patent by nullity action has become more difficult. So could you comment the European situation?
Well, at the EPO, we have the lucky situation that we can appeal an opposition division directly at the EPO. So an appeal has to be filed within 2 months of the notification of the contested decision. So 2 months after you receive the written grounds of the opposition division's decision in your case, you have to file the appeal and you have to pay the appeal fee. And to be honest, it's not a very high fee. For a large entity, it was just raised to 2,255 euros, and small entities, small, medium-sized enterprises, universities, and private persons can get it for 1,880 euros. And after you file your formal appeal, you need to file your grounds within 4 months of the notification. So 2 months after your deadline to file the formal appeal, you have to provide all your reasons why you think that the decision is not correct. An appeal can only be filed if you are adversely affected by the decision. So imagine that the patent is maintained in the granted form, then of course the patentee cannot appeal that decision. The same if the patent is revoked, then the opponent cannot appeal the decision. There is one quite interesting point. In these proceedings, there is the no reformatio in teos principle. So what does it mean? It means if you have the patent maintained in amended form, and you as opponent are the only person who appeals because you think it should be revoked completely, the reformatio in teos would mean that it would be possible for you that the patent after the appeal will be broader than it was before. So your position may not get worse in the appeal proceedings if you're the only appellant. That means if you are the opponent and the patent was maintained according to auxiliary request 4 and you appeal to that, the outcome of the appeal stage can only be better for you, meaning either the patent is more restricted afterwards or completely revoked. As with opposition, the grounds of appeal should contain the complete case of your party, all facts, arguments, requests, and evidence, because even more than in the opposition stage, the appeal stage, later evidence and requests may be rejected by the boards of appeal. And in some cases, during the last years, there was a tendency that some boards of appeal, they took the position, well, it's an appeal, it's not a completely new instance, we only will review the legal aspects of the first instance decision. And there is currently under discussion new rules of procedure for the Board of Appeals, which are discussed at the Administrative Council of the European Patent Convention. And that means that they will put that into a legal frame, that the subject matter of the appeal is the case as it was in the first instance decision. So there will only requests filed in the first instance will be accepted. And additionally, there will be no further technical discussion possible. As I said, some boards do that at the moment, whereas in some other boards, you may, well, start the technical discussion all over again. That may change in the future. It remains to be seen. So that has the effect that you should really put forward all your material against the patent in the first instance already. And usually, again, you have one round of submissions before you receive the summons to oral proceedings, again with a preliminary opinion, which is maybe sometimes not as detailed as in the first instance. And again, this is officially. Nobody will object if you file further statements before you receive the summons to oral proceedings. And in this case, you have a deadline for final submissions. It's 1 month before the hearing. And another thing which may happen is that the Board of Appeal, they will not decide completely about the opposition case. They can remit the case back to the opposition division. Imagine that you have a patent and you attack it for a lack of novelty with respect to document 1, and also with respect to inventiveness with respect to documents D1 and D2. And the opposition division comes to the conclusion, yes, a lack of novelty, we revoke the patent. And it goes up to appeal, and the Board of Appeal says, no, we think that the subject matter of the claims is new. But we won't decide about inventiveness. We will send it back to the first instance because they have to decide whether it's inventive. So it may happen that there will be a ping-pong play between the opposition division and the appeal Board of Appeals until a final decision is rendered. Depends on the, which grounds have been raised and which grounds have been discussed by the first instance at the opposition division. The current time frame of an appeal proceedings at the EPO is 3 to 4 years. And during the last years, it even grew more because there had been problems with restaffing Board of Appeals at the European Patent Office. And according to the latest changes, it's intended to decrease that by increasing the productivity of the Board of Appeals. So they should render more decisions and they should render that faster. And that's maybe also the reason why they want only to have them review the legal aspects of the first instance decision, because of course that's faster than if they have to get into all this technical, procedures again.
Well, thank you for the description. So we saw that there is quite a difference between Japan and Europe on the opposition system, especially with regard to the speed of the procedures, but the oral hearing and also the possibility to file on an appeal. So now that the patent is finally maintained, what are the options? Robert, could you please describe the invalidation proceedings in your jurisdictions?
Yes, as I mentioned before, we have the, let's call it problem, that the European patent is divided into a plurality of national patents after it has been granted. That means that at the moment we don't have any centralized invalidation proceedings because you have to file a nullity action in every country where the European patent has been validated. And also we in Murgitroyd cover a lot of these jurisdictions in-house. I can only refer to German jurisdiction. And of course, in Germany, well, it's a very important market of high importance for all the patent owners. And the good thing is that if you have a nullity action in Germany, many of the smaller countries, they tend to follow the German decisions, which have a very good reputation. And a German national invalidation proceedings, they have the format of a court action at the Federal German Patent Court. And it's not like opposition proceedings. It's really a court action with their own procedural rules, and it's a rather formalistic proceedings. In some cases, patent owners or parties trying to invalidate the patent, they not only get a patent attorney to represent them, but also have attorney at law in these cases. Again, it's open to general public. You don't need any legal interest. And there is no deadline. You can file it as long as the patent is, in force or even after it has expired. In this case, however, you need a legal interest. If there is an opposition pending at the European Patent Office, you're not allowed to file a invalidation proceedings at the Federal German Patent Court until the opposition has been terminated. That may be different in other countries. I know that, for example, the situation in France is that you need a legal interest. In Italy and Ireland, you can file the nullity proceedings before the end of the opposition, but they will stay the proceedings. One point, which is, of course, due to the nationality of the proceedings, the language is German, but the language of the European patent is relevant if you have to decide about the literal meaning of terms and how a person skilled in the art would understand the terms of the patent. So, of course, meaning that the proceedings are in German, you have to consider translation costs. For example, if you're a Japanese opponent, you need to have translations into English mainly. So once you receive a counter statement filed by the patentee, which will be in German, or if you have a preliminary opinion by the court, you need to translate that and forward that, which incurs some additional costs at that time. Again, you will have usually one round of statements. So you file your grounds for invalidity and a reply by the patentee, and then usually you would already receive a preliminary opinion of the court, and that indicates the main issues which are to be discussed and setting a date for oral proceedings. And that scheme with a preliminary opinion of the court has only been introduced into the German nullity actions about 8 years ago. And the reason was for speeding up the proceedings, trying to get the parties focused on the main issues which have been identified by the court. In preparation of the oral proceedings, you will have one more round of statements in preparation. So the patentee usually files all his requests and his additional claim sets, and you may then reply to them before the oral proceedings. A very, very important difference between an opposition at the EPO and a German invalidation at the Federal Patent Court are the costs. At the EPO, each party bears its own costs. So even if you lose, you don't have to reimburse the other party. However, at German nullity actions, there will be a decision on the costs rendered by the court, and the losing party will have to bear the costs of the winning party. Meaning that if the patent is completely revoked, the other party has to reimburse you 100% of the costs according to the, they will not fully reimburse your actual costs, but there will be a limit set for the reimbursable amount. And that reimbursable amount, it's depending on the value of the case. And if you have a value of the case of 750,000 euros, you have to consider that the court fees to be paid are around 20,000 euros. And if you lose at the first instance, you will have to pay the court fees and you have to reimburse the other party costs in the amount of roughly 12,000 euros. If the other party is represented by an attorney at law, in addition to a patent attorney, it may be even possible that you have to pay the double amount to the other party. So that's the main one of the real crucial differences between opposition and invalidation proceedings. And there are some other differences. The possible grounds for invalidation are the same as in a European patent opposition at the EPO. However, there's one reason, one additional reason, and that's the fraudulent abstraction. And I had to really, I had to look for the correct translation, and that means that the applicant is not entitled to the patent, and that the real person, the person who's really entitled, then may file a nullity action because the patent owner is not entitled to the patent. That's not a reason at the EPO, but at the German patent office, at patent court, you can raise that reason. The German patent court is not bound to an earlier decision of the EPO. So if the patent survived an opposition, it not necessarily means that it will also survive a nullity action. In many cases, of course, the EPO decision is an indication. But as I said, the court is not bound to that. You can also raise the exactly same grounds as in the earlier opposition, but it's also advisable, of course, to rely on additional documents if possible. So if you come up with another patent search after your opposition and you find documents which are novelty destroying, you can, of course, use them at the nullity proceedings. It's a different new proceeding. In that case, it may be also interesting that the time frame until a decision at the patent court is at the moment 25 months. Again, a bit more than 2 years. And I talked about that you may rely on additional documents. And there's also one important difference between the nullity action and the opposition at the EPO, because in the German court you have additional prior art in form of national earlier rights. So earlier rights, these are pre-filed but post-published patent applications. And at the EPO, only pre-filed and post-published European patents will be considered. Whereas if you have, for example, a German patent which has been filed before your priority date of the patent, but has been published after, you can use that to attack the patent for novelty at the German Federal Patent Court. You could not use such documents but at the European Patent Office, but you can use them at the German Federal Patent Court. So that's a very rough and fast summary about the first instance decisions and proceedings at the Federal German Patent Court in nullity actions. If you then have your first instance decision, the question is again, can you appeal? Well, you can, and you will end up at the Federal German High Court in Karlsruhe, so a very high instance, the last instance, and you need to file an appeal within 1 month of the notification of the contested decision. Again, you've got another 2 months to file your grounds, and again, you're only able to appeal the decision if you're adversely affected by the decision. And again, as it was with the EPO appeal, there is no reformatio in peius. So if you file an appeal and you're the only appellant, you cannot receive a result which puts you worse than at the first instance. Once you file your Federal German High Court appeal, the court will review it for admissibility and then summons for oral proceedings. And it may ask you for further statements, but it doesn't need to. One more thing is, usually at the Federal German High Court, there are only a very limited number of attorneys at law allowed to represent, but patent attorneys in these cases are allowed to represent at the Federal German High Court. However, it's highly advisable to also include an attorney at law in this stage, because due to the procedural law, which can be rather complicated on the one hand, and on the other hand, of course, these, I think it's 100 patent attorneys at law who are allowed to represent at the Federal High Court. These know the court knows these attorneys, and so the judges, well, it's a personal relationship. They know how to trust, and they can trust the attorneys. Again, if, as we have it in the first instance, new evidence, arguments, and requests may be rejected as late filed, and in principle, it's only a legal review of the first instance decision. That was changed also about 8 years ago. Before that, we had large technical discussions before the, the Federal High Court in nullity actions, and that has been reduced in order to speed up the proceedings. However, a legal review means, it's quite interesting, legal inventiveness is regarded to be a legal aspect. So the court may discuss inventiveness. And for that reason, they sometimes may call for a technical expert. In most cases, where if it is a more complicated technical invention, they refer to a technical expert, which then gives an expertise in the oral proceedings, or even before in a summon or in a written statement. The decision again is taken during oral proceedings, and the time frame again is 2 to 4 years. And again, we've got a decision on costs. The losing party bears the costs, and it's a high cost risk again, depending on the value of the case, and the costs are more expensive than in the first instance. There are at the moment around 60 new cases per year at the Federal German High Court, so it's not as many as in the first instance. And I think, of course, it's due to the cost risk, and many parties are, well, they're happy with the first instance decision and don't want to put themselves in economic risks again. So how's the situation in Japan, Yoshi-san?
Yes, so thank you, Robert, for the explanation. Let's compare now with the procedure in Japan. Sonoda-san, could you please explain us the procedure as well as the reasons to invalidate and how to appeal a decision by the board?
Thank you. Now, this is about the nullity action at the JPO. And the difference compared with the opposition at the JPO is that the only interested party can file a nullity action. And this makes a big difference. You may remember that for oppositions, you can use a straw man, but for filing a nullity action, you must disclose your name and confront the patentee. And this means that the interest is a legal interest. Therefore, it is highly likely that the patentee assumes that you are infringing or is going to infringe in the future. Therefore, this will put you at our potential infringer position. So you must be aware of this. And the cost is twice or 3 times as much as for an opposition. Then here you can see the cost for official fees you have to pay to the JPO, which is the 300 euros for opposition and 700, 800 euros for nullity action. However, the actual cost is the attorney fees, which is a lot higher than this official fee. But the attorney fee also is twice or 3 times higher for nullity actions than for oppositions. And it is because while the opposition is just a one blow punch for the invalidation, and you file just one document and say this patent should be invalidated, and then the examination is in the hand of the patent office. However, in nullity action, so it is our inter-partes proceedings. So you exchange opinions between the the filer of nullity action and the patentee, and back and forth. And almost at the end of the proceedings, you have oral hearing. Therefore, this is a kind of full menu, and this tends to be more expensive. But still, the decision can be expected within a year. And about the attorneyship, usually you do not use our attorney at law for this. And patent attorneys can handle, and in most of the cases, patent attorneys handle nullity actions. And with regard to the grounds for raising nullity action, almost the same as the opposition, because you can raise any reason for invalidity of the patent. And on top of that, you can question the ownership of the patent, that it is similar to the situation in Europe. And in here, opposition, the Board of Appeal is bound by the reasons and arguments and cannot raise any additional reason by itself. So the question is whether the filer of a nullity action succeeded to prove to the satisfaction of the Board of Appeals that there is a good reason to invalidate the patent. And once a decision by the board of the JPO is given, either party can appeal an unfavorable decision. And therefore, in opposition, only the patentee can file an appeal to IP High Court, but in nullity actions, either party, if this is dissatisfactory for the decision, can file an appeal to IP High Court. And statistically, nullity action had 60% success rate some time ago, in 2006. However, the success rate for the nullity action has dropped gradually during 10 years. And in 2016, it was about 30%. So it has become more difficult to invalidate, even by the nullity actions.
Thank you. So now could you please summarize briefly the main differences between opposition and nullity action, so it's in each jurisdiction for each one of you, and also give us some recommendation on which one to choose, which options to choose, like nullity action or opposition. Thank you.
Yes, so the comparison of opposition and nullity action in Japan first. With regard to the term of filing, opposition has a limit, 6 months from publication of patent, while nullity action has no limit. Therefore, if you need more than 6 months to prepare arguments or to prepare test data or anything, you cannot file an opposition, and you should consider filing a nullity action. And especially this 6 months is short, I believe, for non-Japanese people, because you must translate the granted patent, and you must translate your argument into the Japanese language. And considering this time, 6 months is usually not enough. So this works in an unfavorable way for non-Japanese entity, I'm afraid. And the second difference is eligibility for filing. The opposition can be filed by any third party, and nullity action, for filing a nullity action, you need legal interest. Therefore, the difference I explained already, you can use straw man for opposition, but you must disclose your name for nullity action. And for the reason for reason for filing, are almost the same, but nullity action has one more reason, which is the right of ownership. And with regard to the proceedings, the opposition is one blow by the opponent, and the rest is given to the jurisdiction of the board. And whereas the nullity action is an inter-part proceedings, so the opposition is more difficult to invalidate, as the statistics tells. The success rate of opposition is about 12%, while the success rate of nullity action is about 30%, so more than double. Although the success rate is not that high, there is a substantial difference. And proceedings is documentary for opposition, and nullity action is documentary plus oral examination, which is a crucial part. And with regard to a withdrawal, there is a difference. You cannot withdraw your opposition after the Board of Appeal issues a notice of reason for revocation. And nullity action can be withdrawn any time before the finalization of the decision. The finalization of the decision means even if you receive a decision by the Board of Appeals, that is not yet finalized, because you can file an appeal to IP High Court, for which you have usually more than 30 days. And within these 30 days, you can withdraw your nullity action, and everything will become indefinite. But in opposition, because you cannot withdraw opposition after the issuance of a reason for revocation, it is difficult to use the opposition as a tool for negotiation. In negotiation, for example, you file an opposition or, nullity action, and send a message that to the patentee that the patent could be invalidated, and start negotiation for license at a lower fee, for example. The nullity action can be used in that way, but opposition cannot. That is one big difference. An official fee is like written here, and which is not substantial anyway. The substantial part is the attorney fee. And with regard to the speed to come to a decision, you can expect the final decision about opposition within 6 months. In average, it's 5.8 months. And nullity action takes 1 year. Both are very fast compared with the other jurisdictions, but still opposition is very quick. And as appeals, there is a limitation about the appeal for opposition decision, but for nullity action, you can always appeal to IP High Court. And could you explain the summary in Europe?
Yes, I will do. As we learned, at the EPO we have centralized proceedings, whereas in invalidation actions you have a plurality of national proceedings. At the EPO, each party bears its own costs, whereas in invalidation, the losing party bears the costs, which can be quite expensive. EPO opposition is rather cheap. The official fees are about 785 euros, and you've got even the appeal fees at the amount of 2,200 euros, whereas even at the first instance, you may face court fees already in 20,000 euros. On the other hand, you have additional national earlier rights for invalidation proceedings, whereas at the EPO, you only have the EP earlier rights. One drawback, of course, as it's the same situation as in Japan, that an opposition can only be filed within 9 months after grant, whereas the invalidation, there is no deadline for filing the court action. And what's also quite good, you can file an invalidation even if you lose your opposition. So it's possible in addition to the EP of opposition. again, it's a similar situation as in Japan. The EPO opposition, even if you withdraw your opposition, the EPO may continue with the proceedings and render a decision. So if you come to an agreement with the other party and you withdraw your opposition and there is a very good case at the EPO, the opposition division may revoke the patent anyways, whereas in invalidation proceedings at the Federal German Patent Court, if you withdraw the action, it's terminated. So as a conclusion, I think due to the first 3 points, EPO opposition seems to be advisable here. And I think that's our advice, if you can file an EPO opposition, because you always have a second shot with nullity actions here. And I think, Yoshi, you have a current trend to consider with the JPO in this case again.
Yeah, thank you. Some thoughts, some data about the statistics of opposition. Here is the statistics taken from the opposition filed in 2015. And this is the year the new opposition system started. And there were 367 oppositions filed. And for that, 362 decisions have already been made. Therefore, almost all of them have decided. And the conclusion is that 46 patents were revoked, which means 12.7% were revoked, whereas the 167 patents were maintained and 4 requests for opposition was withdrawn and 1 is still pending. So it tells that if you look at the number of revoked patents, it is 12.7%. Therefore, as a tool to invalidate a patent, this is not that strong. This might be the result of the recent pro-patent trend at the JPO. And if you compare this 12.7% with the success rate of nullity action, as I stated before, nullity action is successful in 30% of the cases. So clearly, nullity action are more successful than oppositions. However, there is a little more detailed analysis about what happened. In the decisions to maintain a patent, the claims were amended in 51.3% of the cases, which is 50% of the cases. So if the target of filing an opposition is to make the patentee amend the claims, you can say that was successful for more than half of the cases. However, there is something you should consider. That is, the opponent files its opposition and opinion to invalidate the patent, but the examination after that is in the hand of the Board of Appeals of the JPO, and the JPO and the patentee exchange opinions and even makes oral face-to-face meeting with the examiner. And therefore, how to amend the claims are totally in the hands of the JPO and the patentee. The opponent cannot control the amendments other than the first blow, or once the amendment is made, opponent can file one opinion against the amendments. But that's all about the contribution of the opponent. Therefore, the opponent cannot directly influence or control the amendments of the claims. So considering that the 51.3% of the amendments may not be always a success for the opposition, but this is the statistics, and whether you think this is a successful result or not enough will depend on the situation. Some words about the strategic choice at the JPO between opposition and nullity actions. So given all the limitations and the characteristics of oppositions and nullity actions, we believe that the opposition is advantageous if the interest is to lower the cost and to speed up, because you can get the conclusion within 6 months. And the anonymity is important. When one of these three are very important, it would be a good choice to file an opposition. In contrast, you should go to nullity action if the invalidation of the patent is the utmost importance, or 6 months is too short, or you have to raise a question about ownership of the invention, or if you are going to use this tool as a tool for negotiation for license. In these situations, you should consider, or rather choose, nullity action rather than opposition. That is our advice. Could you comment a little about the unitary patents? Sorry, I should proceed.
Thank you
Yes.
very much. Yes, please, Robert, please comment on the situation in Europe, whether or not it's going to change with the unitary patent.
Well, one of the main aspects in introducing the unitary patent system was that, as I said before, after grant of the EPO patent, it splits up in national patents, and that's supposed to change. There will be an invalidation action for a unitary patent as a whole, and that will need to be filed at the Central Division of the Unified Patent Court. And so you have, again, centralized proceedings, and one decision will be relevant for the full territorial scope of the unitary patent. Another advantage maybe is that the language of the proceeding is the language of the patent. So if you've got an English patent, you don't need to have all your proceedings in German, for example. There are some translation issues, but not in this context. There will be a very strict time frame. At the moment, the plan is to render a first instance decision in 12 to 15 months. This sounds very advantageous, but you have a very high court fees and you have a high cost risk. Again, this is based on the value of the case, and the problem is in an average value of a case here in a German nullity action, it starts at 750,000 euros. And if you calculate that a unitary patent will cover 10, 15, 20 jurisdictions, the value of the case, in my opinion, will be at least 3 to 5 million. And then you can have reimbursable costs which may exceed 200,000 euros for your patent. If you're a patent owner and you lose your patent, you may be forced to pay the other party 200,000 euros, which is a lot of cost risk. And again, you have an appeal which is possible for these invalidation proceedings at the unitary patent. And another thing which is, I think, at the beginning a disadvantage, you don't have any case law at the moment. So you're walking into unknown territory. You don't know how the judges will decide on inventiveness and on, added subject matter and things like that. So there are some advantages, but also disadvantages with the new system. But the question is, where are we at that UPC and the unitary patent at the moment? It has been promised for the last 40 years. We were very close in getting it started, and then we had some issues with Brexit. At the moment, we've got a court action pending against the unitary patent system and court system at the German Constitutional Court. And that's why Germany at the moment stopped the ratification. and the German Constitutional Court, they plan to have a hearing and a decision rendered in this matter during this year, which, well, is quite interestingly, but we don't know when this will be. So as I said, the decision is expected this year. And if the decision is positive, so that the unitary patent court system does not violate the German constitution, then we may in fact see a very fast ratification by Germany. And you know, this slide is already outdated because the United Kingdom ratified yesterday. So at the moment, the eyes are on Germany and whether the German Constitutional Court decides in favor or against the unitary patent system. If it is in favor, the system will enter into force within months. However, we don't know what will be the effect of Brexit. Some people say London, the UK cannot stay within the agreement. Some say it can stay in the agreement. We'll have to wait and see. And there are even rumors that the German Constitutional Court, they will extend the proceedings until the effect of Brexit is there in order to have at least not a situation before Brexit which may lead to a lot of problems afterwards. So I think with respect to oppositions and nullity actions, we may expect that it will be easier to have a nullity proceedings against a granted European patent after the system comes into force, but it's also got its disadvantages. And I think that's all for the moment. Thank you for staying with us so long. I know we took longer than expected, and I hope that we still have some time for the question and answer section, and I think that's Luca to decide. Thank you for your audience.
Well, thank you very much for attending this webinar. So let's proceed now to the question and answer. We have one question already in the chat, so you can feel free to write down your question on the chat on the right hand of your computer. One question for Sonoda-san from Mr. Modran-Ludwig. Can the opponent introduce new reasons for opposition anytime?
No is the answer to the question, because in the opposition, the opponent can file its opinion at the beginning of the opposition proceedings. And that's all, except when the patent claims are amended by the patentee, wherein the opponent can have the second chance to submit its opinion. But the second opinion must be directed to the amended claims only. Therefore, I have to say that there is one blow and there is no second chance. Did it answer the question?
I believe so. We'll have a look in a moment. So another question from Mr. Bedenbecker. For those who are interested in the future development of the EPO in their activities, you may want to check for the user consultation on the revision of the rules of procedure of the Board of Appeal. Robert, do you have any comment on this comment?
Well, I think it's a good point. As I said, the rules of procedure are now under discussion, and there are some quite important changes coming up. As I said, only a legal review of the first instance decision. Another point is that the Board of Appeals may render a decision without delivering grounds for that if the parties agree or under special circumstances. So you will only receive the minutes of the decision. So I think it's a really good comment by Mr. Biedenbecker, and I really, I also can ask everybody to have a look at all these developments and to see the consultations. As more stakeholders put in their comments, the better the outcome will be for us in the end.
Thank you. And another question to Sonoda-san from Ms. de Chateau-Thierry. Are prior uses possible grounds for opposition before the Japan Patent Office, and which level of proof would be required?
Yes, that can be a reason for opposition or nullity action for both of them. However, I have to remind that if there is a patent application filed in the JPO prior to the patent application in question and published after that, then you can use this as a reason for opposition or nullity action. The prior application in other jurisdictions will not work in the same way. You cannot use the prior application in EPO or in the US.
Another question, is it better to patent in German or English? From Mr. Schneider. I believe that this is directed to Robert.
Well, is it better to patent in German or in English? It's a very good question. I think translations are always problematic, but if you intend to use your patent afterwards, not only in Germany or at the EPO, but also in other countries like Australia or the US, it may indeed be a very good advice to already draft and file the application in English at the European Patent Office. And the good thing, even if you file it in Germany, the German Patent Office now offers 12 months before you have to hand in a translation. So if you draft in English and you hand it in at the German Patent Office, you will have your first search results or even your first preliminary examination results before you have to decide whether or not to file a translation. So I'd say if your main aspect is not only Germany, but if you want to file at the EPO anyways and in other countries, it seems advisable to use English.
Could I comment about the language in the Japanese jurisdiction? When you file a patent application through Paris route, you have two choices, whether to file in the Japanese language from the beginning or to file it in any language, in English or German or French or any language, and file a Japanese translation of the original filed application within 4 months. And we recommend that you follow the second route, which is to file in the original language and then file translation. The reason is when there is a problem of translation found later, if you file the original language and then the Japanese translation, if you did that, you can always go back to the original language and correct the translation problem. So that can be a huge advantage sometimes.
Well, thank you very much. We'll accept the last question and wrap things. So thank you for your answer about prior use before the GPO. So Ms. Dr. Chateau-Thierry, I have a second question about the level of proof compared to the EPO practice, which is beyond reasonable doubt. What about the practice in Japan?
This is about the JPO and for the prior right. And therefore, the reason for revocation by filing opposition or nullity action must be based on the patent application filed in the JPO. Therefore, as for the evidence, it is clear. You have a prior application and the patent in question. And in this situation, what you can do is to attack the novelty of the patent. The patent in question cannot use it to attack the inventive step. Therefore, you cannot combine two applications. As far as the patent in question is disclosed somewhere in the application or drawing of the prior application, then you can invalidate the patent.
Thank you very much, Martha, for your answer. Thank you to all the audience. I will let Luca have a conclusion on this webinar. Thank you.
Thank you, Diane, and thank you, Sonoda-san and Robert. You have been amazingly good at explaining, giving us more than an idea about the today's topic. I think that everybody was really happy to hear what you had to say. We set a new record for the webinar. We have been glued for 90 minutes, so congrats for that. And all of the participants stayed with us, so I'm very happy to report that as well. Just to give any information to our audience, the materials will be uploaded. We will have also the webinar, the video of the webinar uploaded on our YouTube channel, so you will be able to rewatch it or share it with friends and colleagues. So please do it. Again, I would like to thank our speakers of today, and of course all the audience, and also remind that at the end of May 31st, we have the next webinar number 19. It will be on innovation and how to build an IP portfolio, especially for startups, with a speaker from Palo Alto. So the timing will be a little bit different. It will be afternoon in Europe. So without further ado, thanks again to everyone, and I'll see you soon, and have a great weekend.